What is going on, everybody? Frank Corva, White House and political correspondent for Bitcoin Magazine here. Super pumped to be joining you all on the stream. Thank you so much to Stand With Crypto for giving Bitcoin Magazine, the Bitcoin Policy Institute, and Bitcoin Laws this hour. I'm going to kick things off right now with Shinobi, the technical and opinion editor for Bitcoin Magazine, as well as Zach Shapiro, head of policy at the Bitcoin Policy Institute. Gentlemen, welcome to the show. How are we doing today, Zach?
Doing great. Thanks for having me.
Excellent. Shinobi, how's everything over there?
Hanging in there, I guess.
Looking good, looking good. All right. So, Zach, I don't want to waste any time. I think we're gonna break this up into two 25-minute segments. So I want to dive right in here. Zach, we were just together at the courthouse downtown in the Southern District of New York for both the Tornado Cash trial and also for the Samurai, the situation where they accepted the plea deal, pled guilty to the money transmission charge, and we were, I'm not sure you were there that exact day, but we were in the courtroom during the trial for which Roman Storm ended up being found guilty of this money transmission charge. What does this mean for transactional privacy moving forward? Where do we go from here?
Yeah, absolutely. I think this signals some real danger for not just transactional privacy, but the future of peer-to-peer payments and financial infrastructure writ large. The crime for which the defendants in both the Samurai Wallet and Tornado Cash cases were convicted is a little bit confusing. Technically, it's a conspiracy to operate an unlicensed money transmitting business. Although the government allegations at the beginning of each of these cases did actually allege that the defendants required a license to run their respective non-custodial businesses, they dropped that object of the conspiracy. And so effectively what everyone was convicted of is a crime that consists of operating a business where there was money that was transmitted by the business and where the defendant knew that some of the funds that were being transmitted were the proceeds of crime or an attempt to hide the proceeds of crime. The problem is, if you really think about what that means, if it is possible for you to transmit funds without being in custody of those funds, and only other ingredient it takes for you to commit a federal crime is to know that some of those funds were the proceeds of crime, this would apply to almost anything in the crypto space, right? Anyone who runs a node, anyone who offers a non-custodial wallet that allows you to generate private keys or broadcast transactions, Bitcoin miners, Ethereum staking nodes, layer twos, any kind of DeFi protocol, you name it. And so we need to make sure that we don't unintentionally set a precedent that goes way wider than the law anticipated. What it means to be a unlicensed money transmitter, the concept ultimately comes from a law called the Bank Secrecy Act, which says that you are a money transmitter if you accept and then transmit funds on behalf of the public. For most of the short history of the crypto space, people understood that to mean that between accepting and then transmitting funds, you needed to be in possession or in control of those funds. Just logically, that's entailed by the language. And this was backed up by guidance from FinCEN, which is the regulatory part of the Treasury Department that enforces the Bank Secrecy Act. And these two cases, and specifically the prosecutor's theory in these cases, leads to these really wild results where if you can somehow transmit funds just by providing infrastructure that other people use to transmit their own funds, there are very few software developers or service providers in the crypto space that are safe from this, including folks like open source wallet developers and Bitcoin miners who literally physically can't comply with the KYC AML required by the Bank Secrecy Act. So the first thing I think that needs to happen is we need to overturn these precedents, and there are two good shots on goal in this. One is the appeal in the Tornado Cash case. Roman Storm intends to appeal before the Second Circuit the ruling that the Tornado Cash service, including the smart contract, the pool, plus the front end that didn't take custody of funds and the relayers that didn't take custody of funds, and the fact that he ran servers for both of these, that constituted money transmission. And then there is a case, Llewellyn versus Bondi, that's working its way through the courts, where the plaintiff, Michael Llewellyn, is suing the federal government to try and overturn the precedent from the Tornado Cash case. But the longer term fix to this that doesn't really rely on a judge that may or may not understand the underlying technology really well is a piece of legislation called the Clarity Act, which was passed through the House of Representatives, that is being worked on in the United States Senate, They have a discussion draft out. They'll probably vote on that legislation by the end of this year, and then that would be signed into law by the White House. And so I think in terms of what we need to do to protect open source developers, to protect non-custodial technology, and then by extension to protect individuals' rights to privacy, is to make sure that this Clarity Act goes through and makes crystal clear, even to prosecutors who would say otherwise, that the Bank Secrecy Act only applies to people who are actually transmitting money in that they have custody or control of that money.
Appreciate that overview, Zach. Thank you for breaking it all down. Shinobi, we've had this conversation a lot about, so ideally things break the way that we want legally. We see maybe a better resolution when the Roman Storm case, when it goes to the appeals court. But on a certain level, anybody who's developing this technology is feeling the chilling effect that is sort of permeating the air at this point. Should devs remain anonymous if they're building this sort of technology at this point?
I mean, I think that's definitely something to at least very seriously consider, like from your personal point of view. Like I'm aware of developers in this space who kind of had that existential wrestling period with themselves of, am I okay with going to jail for this potentially? But that is a very serious risk in the wake of these cases. And just the absurdity of the nature of this, being convicted of doing something they did not do, like as explicitly clarified by the relevant regulators, is just absolutely absurd. Like the message that sends is, we will just fabricate and invent excuses or reasons to prosecute developers for whatever reason we think of, no matter how many times along the way regulators clarify this is incorrect. Like the expert witnesses that, if I remember correctly, in some of these cases were not even allowed to testify to the fact of how this works, all the way up to actually like pressing charges. It's just absurd for the fact, for things to have gotten to this point in the first place, is just all bets are off. And that is absolutely something anybody building anything in this space should consider. Zach, you spoke to how this precedent could broadly apply these requirements to all kinds of infrastructure providers in the space. I mean, given the absurdity of this in the first place, I would argue that could potentially even go further. If I start tagging Google on Twitter or other social media and tell them, hey, I'm using Gmail to mail digital currency around and transmit value, are they now, because of their awareness, a money transmitter? Do they have to go through these licensing requirements? Like, it's insane. Like, especially in Samurai's case, they did operate a centralized service, unlike Tornado Cash, which was fully autonomous on the Ethereum blockchain. But that server that they operated did absolutely nothing except facilitate messages being passed back and forth between their end users. At no point did it facilitate conveying value. At no point did it have control over any user's funds. They were simply a message coordinator so that users could collaborate amongst themselves to sign a transaction involving all of their funds. And for that to be considered a money service business, like, how is that different than any messaging platform that exists on the internet today? We can pass messages through whatever we want. And Bitcoin transactions at the end of the day are simply pieces of data with a proof of authorization from another piece of data, your private key, your secret key. And like, that's just the nature of how this works. So like, taking this to the absurd extreme, like, what is the liability here?
It's a really big question. Zach, I want to go back to what you just mentioned about the Clarity Act. So the Clarity Act borrows some language from the Blockchain Regulatory Certainty Act, which is a relatively brief bill. I think it's just 2 pages long. Bipartisan support. I think we saw Tom Emmer come out in support of it. Representative Richie Torres come out in support of it as well. Can you talk a little bit about this language, especially the language that was sort of lifted from the BRCA, from this act, brought over to the Clarity Act, and what this would mean in terms of sort of superseding everything that just happened with the Tornado Cash trial, with what happened with Samurai? Not that the plea deal is the same as the outcome of the trial, and what that would mean for developers moving forward. Would this sort of remedy some of these issues that both you and Shinobi just mentioned?
Yeah, I think the Blockchain Regulatory Certainty Act, the certainty we're seeking about, is exactly about this question that we've been talking about. The problem with the government's theories in the Tornado Cash and Samurai Wallet cases is that it has no limiting principle, right? I think you can take it to even more absurd extremes, even than Shinobi was saying. If all it takes is for you to facilitate others' movement of money to be a money transmitter, then the timber company that chops down the tree that becomes paper, that becomes the envelope that one criminal uses to hand cash to another criminal is a money transmitter because that would facilitated the cash transaction. And that's ridiculous. And so I do think we need to ask the government, what is the limiting principle? Where does this end? What is the line between you're a money transmitter and not? And we need an answer to that question. And in the very early days of Bitcoin and crypto, this was an open question. The attempts at creating electronic cash before Bitcoin mostly failed because of money transmitter regulations. Things like DigiCash, eGold, Liberty Reserve had a centralized party that was deemed to be a money transmitter, and these things got shut down. And what was different about Bitcoin is that it was a peer-to-peer system, right? Through solving the Byzantine generals problem through proof of work, Bitcoin invented a way that you could actually directly operate on a peer-to-peer basis. And for the first time, you could transfer money electronically without an intermediary. But then, of course, our laws presume that if you're going to transmit money electronically, there has to be an intermediary that can be regulated. And that's really the cause of this tension that we're seeing in these cases and in the courts right now. So the Blockchain Regulatory Certainty Act draws upon guidance that FinCEN put out in 2013 and 2019 that really sort of drew the early line for who in the crypto space is a money transmitter and who is not. And the line was what they called total independent control, which says, do you have essentially custody of other people's funds? Is a user of a product interacting with the blockchain directly, and they're just using an interface like a front end or a wallet that helps them generate private keys? Or do they have an account with a service provider like an exchange or a custodial wallet where they are using someone who really is more of a financial service offer? And the Blockchain Regulatory Certainty Act writes into law what FinCEN had put in its guidance, that in order to be a money transmitter under the Bank Secrecy Act and similar regulations into the future, it needs to be the fact that you have custody and or control of user funds, total independent control. And that would capture really, I think, what the industry has come to expect, which is if you're a custodial exchange, you are subject to the Bank Secrecy Act, you are a money transmitter, you need to get licenses, you need to KYC. If you are just someone who publishes software, whether that software is a non-custodial wallet or whether it's a smart contract that allows people to trade assets between each other on a peer-to-peer basis, where the person transmitting the money is not the software developer that built the tool, it's the person who holds the private keys to the assets that are being swapped, then you are not going to be treated as if you were a regulated financial institution any more than someone who creates builds a USB cable is responsible for any crime that is committed by putting data through that cable. It's really the line between a service and between infrastructure.
Okay. Shinobi, one of the things that, it's something that goes back as far as Hal Finney talking about is, so Bitcoin, we sort of know that the base layer of Bitcoin is something that it's not going to be maybe something that, at least not in its current form, the current iteration, without certain improvements made to it. It's not going to be something that everybody can use. Not everybody in the world is going to be able to have a UTXO. It'll be too expensive to transact on. There'll be many things that inhibit people from doing that. So we could end up in a world like Hal Finney predicted, where we do have Bitcoin banks and obviously a different sort of regulation that will need to address that, because then there will be actual custody. But I want to talk a little bit about what we can maybe do to sort of reduce the need for Bitcoin banks as much as possible. What improvements can we make to Bitcoin so that people can be as self-sovereign and sort of ideally we get past this stage of lawfare and these issues with Samurai and Tornado Cash, and people are able to use Bitcoin freely, on their own autonomously. But what do we have to do for Bitcoin to sort of improve to get to a level where people can do that on a technical level?
We're going to have to upgrade the Bitcoin protocol itself. Specifically, the most prominent direction is a class of different upgrade proposals called covenants. And the general idea of what they do is essentially restrict how coins can be spent into the future. So say you have a normal UTXO, that can only be spent proving that you have control of the relevant key it's locked to with a signature. And then from that point, you can do whatever you want with that UTXO. The idea of a covenant is to add extra restrictions beyond prove you have control of this key. such as if a bunch of people are sharing a UTXO, some type of proof that the money you are trying to spend out of that is something that everyone involved agreed to, that this is the correct balance distribution. And another such restriction would be ensuring that the rest of the money must be spent back into a UTXO still locked by that covenant, so that the rest of the users still have the ability to prove their current balance and withdraw that if necessary. And essentially just kind of create an arrangement where people can pool control over their UTXOs safely and actually have the base layer protocol of Bitcoin enforce that those arrangements execute correctly. That when
Okay.
balances are shuffled around and people trade money amongst each other, that new balance arrangement is something that any of them can enforce and withdraw their money from on chain at any time. And
Oh,
this is absolutely necessary to really have Bitcoin function as a system that can be resistant to the state. Like we need an option to interact with this system that is not custodians, that is not putting someone else's unilateral control between you and the actual Bitcoin network that is enforcing all of these rules and ensuring that transactions are correct and valid. Like users need a way to interact with that directly. And the economics of having a limited amount of block space just make that prohibitively expensive. So the only way around that is finding ways for users to safely pool their money together, sharing a UTXO, while still having that strong ability to enforce a claim on their share of that so that they can spread the cost around.
okay. Yeah, because if we do get into a custodial situation, then we're dealing with sort of the laws as they exist in the traditional system. And I guess, obviously we know Bitcoin was designed to be an alternative to that system. So ideally we get to a point where people can use it as such. I want to ask a broader question to both of you. I'll start with Zach here. Biggest concerns moving forward. What does America have to get right regarding Bitcoin and crypto legislation more broadly? And I say this because in the United States, for better or worse, oftentimes the legislation that gets crafted here gets copied and pasted globally. Some iteration of it gets copied and pasted globally. So ideally, we get things right. What does getting it right look like, Zach?
So I can give you a specific and a general answer. The specific answer, I think, is exactly what we've been talking about so far. It is making a priority out of respecting the peer-to-peer nature of Bitcoin and crypto transactions. That is the technology that makes this different from what has come before. There's a lot of energy behind what are perceived to be sort of more economically important questions about what's a security and what's a commodity. And I understand that there's a lot of money behind both of those questions, but that's really a short-term Pyrrhic victory if you can't use the blockchain itself, if you can't operate in a peer-to-peer basis, because then if it's going to be captured anyway, you might as well use the legacy TradFi system. None of this technology provides a benefit other than the fact that it's peer-to-peer and you can self-custody and all of the sort of special and magical properties of Bitcoin, and to the extent that it arises a Web3 economy. I think zooming out and generalizing a little bit, one thing that I think policymakers around the world should realize, and this is really sort of specific to Bitcoin, but it's a broader point, is that you should think of Bitcoin really more as a commodity than as a technology product by any company. And when you think about sort of Bitcoin, and then I think you could probably broaden this out to DeFi as well, really think about this as infrastructure that allows these peer-to-peer interactions. And we have different types of regulations for infrastructure than we do for companies or products. And I think policymakers are well served by having sort of that mental picture when they're thinking about how to regulate these things.
Okay, appreciate that. Shinobi, anything to add to that?
I mean, I am not very optimistic about the near term. I agree with everything that Zach said, but at the same time, my worldview is generally one of skepticism, paranoia, and a lack of trust. And I do not trust at this point that governments will cede very easily the right to privacy in interacting with these technologies peer to peer. I think that is something they will fight tooth and nail. And it's an inevitable thing in my mind, but also a very disappointing and dangerous thing because all of the existing financial regulations as it pertains to privacy, money laundering, related subject, is all predicated on the notion that it is not possible for anything to exist non-custodially except cash. That all digital systems by their nature are inherently centralized and custodial. And so all of this regulation is kind of a dual-sided thing. Like there is the mandate that these institutions and custodians have access and view to all of this private information, but they also have a legal requirement and responsibility to keep that information private from the general public, to safeguard that, because that is their customers' sensitive personal information.
Mm-hmm.
And the way this technology works is just in complete defiance of how they've dually structured that regulation. Like these systems are inherently completely public. Everything that happens on them is public knowledge. They can watch, they can learn, they can find patterns and deduce things from that. The only missing piece that is not inherently publicly available is your personal identity, your actual legal identity and who you are. But once that gets associated with something, there is no way to undo it. And that is a very real and serious threat to people's physical safety with how this technology works. It is completely a bearer instrument. Anybody who is able to get access to your private keys can send that money elsewhere, and there is nothing you can do about it. There is no chargeback, there is no customer support. It's just gone. And in the last year, especially, incidents of people being kidnapped, physically attacked, tortured, just because of the perception that they have some large amount of Bitcoin or cryptocurrency. It's becoming a weekly occurrence.
Mm.
And to not have our government recognize that very real personal risk to people's safety and take it seriously, it's disappointing. It's incredibly disappointing. And I just think demonstrative of negligence in terms of actually thinking about their citizens, their voters.
Deeply sobering as always, Shinobi. Much appreciated. Very important information, though, and I appreciate the way with which you present it because I think it is that stark. There's a very sort of I think I don't want to call it a fight to be had, but there's definitely we're going to have to sort of put our foot down and say this is what's important to us and sort of stand our ground as much as possible on these issues, no question. We have about 2 minutes, gentlemen, so maybe a last 60-second call to action, whether that's, speaking to the general public or Shinobi to devs. I'll start with Zach, but, what can the general public do here if they really do care about P2P rights, what can they do to defend them?
Yeah, speaking to the general public, I'd want to look at 3 timeframes. So looking backwards, I think it is remarkable how much progress we've made in the last year, how much of a important topic of policy consideration Bitcoin and crypto is, how much more seriously our concerns are being taken, how much less regulation by at least new regulation by prosecution or regulatory enforcement actions we're seeing, and how much of a voice we have. I think there's an important lesson in that, in how we conduct ourselves and the results that we've seen. In the sort of short to medium term, I think the most important thing is to sort of fight these battles. We're in a unique moment in time where Bitcoin and crypto is being integrated into various legacy systems, both into government policy, into traditional financial rails, into being a kitchen table issue for people around the world who need a store of value that is safe from debasement and confiscation. And a lot of people who have been in crypto for a long time are probably reluctant to interface with government. They're reluctant to think about some of these issues. And they're adages, right? Like, you can't stop Bitcoin, or everything makes Bitcoin stronger. That's not necessarily true of you. And if you want to live in a jurisdiction where you're not going to be treated like a criminal, where you are going to be safe in your person, your Bitcoin is harder than you are. And so, following policy organizations, donating, calling your senator to advocate for the Clarity Act, I think makes a ton of sense. And then, I do think it's important to end on a note of sobriety here. I think if we extend out to the long term, then my view starts to converge a little bit more with Shinobi's. I think in most ways, Bitcoin and crypto is a completely neutral tool. It is something that all sorts of people around the world who have all sorts of belief systems, and good people and bad people, and capitalists and communists and authoritarians and freedom fighters can all use. I think one way in which it is not neutral, maybe the only way in which it's not neutral, is that incrementally it does take some power away from the centralized state, especially the giant type of centralized nation state we saw arise in the 20th century. And I think this is going to be an important theme of the 21st century, the way that this power ebbs away a little bit. And I don't think that the most powerful nation states around the world, I think especially authoritarian nation states like China, are going to completely take that sitting down. And no amount of court cases or lobbying or anything over the long term is probably the thing that is going to make this technology permanent and live up to all of its potential as a tool for freedom. What is going to do that is the cypherpunk movement that built it. It's the tools that builders in the community are building. It's creating technology that is private by default, that is easy to use, that is a clear 10x improvement from the legacy system that is disrupting, and is unstoppable because it is built on a decentralized peer-to-peer foundation. And so if you're not the type to write a check to lobbyists, if you're not the type to call your congressman or senator, maybe you do have a skill set to get involved in building the technology to take us to the next step, to work on the software and hardware that will bring this technology to the masses and help meet its promise. And I think a lot of the policy stuff that we talk about, while it may be a central part of the story of today, and I think it can't be overstated how important it is, ultimately, in some sense, it's a rearguard action for the stuff that the builders are building.
Appreciate that. On that note, Shinobi, I'm going to hand you the baton. We have about 30 seconds, if you don't mind, if you could just wrap it up for us.
I mean, that's I could not have said any of that better than
Beautiful.
Zach. So
Yep.
I will just say I agree with him.
I appreciate that. Shinobi, Zach, thank you so much for taking the time to join us here. I think we're going to take just a momentary break, and then I'm coming back with Julian Farr from Bitcoin Laws and some of the rest of the editorial team at Bitcoin Magazine. Again, I'm Frank Corver, the White House correspondent for Bitcoin Magazine. I was joined here by Shinobi, technical editor and opinion editor for Bitcoin Magazine, as well as Zach Shapiro, head of policy for the Bitcoin Policy Institute. Stick with us, everybody. We're coming back in just a minute.